Good morning. Are you Federico Ortiz?
Yes, ma'am.
And will your client waive the formal reading of the motion and the indictment?
He will, Your Honor.
Mr. Ortiz, in cause number 25, DCCR 0589, you're charged with the state jail felony offense of abandoning or endangering a child, and that's from December 1st of 2024. And how do you plead to that charge?
Good.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
In that case, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Ortiz is not competent?
No, Your Honor.
All right, sir. In that case, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea.
And just like that, the first guilty plea is locked in. But here's what makes this heavier. A child endangerment charge is already serious enough, and the courtroom drama is only getting started.
Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, in cause number, let me find it, 24, DCCR 2334, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 10th of 2025 for the offense of burglary of a habitation, and that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department for the months of May and June of 2025, and then also July of 2025. Is that true or not true? And then count 2 alleges that you failed to provide verification of performing the community services required. Is that true or not true?
True.
Then count 3 alleges that you failed to provide verification of completing the theft prevention class as ordered. Is that true or not true?
True.
And then finally, count 4 alleges that you're behind in your court-assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes.
I also have here on the tablet, in this case, some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over this with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes.
State tenders number 1.
No objection.
It's admitted. Mr. Ortiz, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find that you're mentally competent to understand the nature and the consequences of those pleas.
This is the part many people underestimate about probation. Miss meetings, skip requirements, fall behind on fees, and suddenly a second chance can turn into prison time. Do you think probation rules are too strict or completely fair?
Find sufficient evidence at this time to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, I'm handing you the trial court certifications that shows that there are agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Good luck to you, sir. You can go back with the bailiff.
Thank you. Thank you, Your Honor.
Thank you.
And thank you, Mr. Rojas. Why not?
Randolph Vines, Mr. Rojas. Mr. Rojas is getting a gold star this morning.
It's been a while since I had one of those.
Rusty star.
Luke deserves to have to put out. Most of these cases are yours.
True.
Oh, well, y'all might have to share a star, huh?
That's right.
I don't require it.
I'll take the whole thing.
It's always nice to get a gold star.
Do I still have it? No.
Good morning. Are you Randolph Vines?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Vines, in cause number 25 DCCR 1154, the state has elected to proceed on count one only, and in that count to the lesser included offense of a Class A misdemeanor, unlawful carrying a weapon, from June 29th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Vines is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of unlawful carrying a weapon, sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
I feel like this might be one. I don't know all the misdemeanors, but I feel like this is one. Yep. So I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges.
Even judges have human moments. Losing track of a routine warning might sound small, but these legal advisements matter a lot. One courtroom slip doesn't erase the reality. These consequences follow defendants long after sentencing.
Against you. You obviously know this based on what you're charged with, but I'm required to read it. And now I forgot where I was, but legal charges
If you have any
against you.
questions
If you
about
have any questions about what, you should read the document I provided you. I don't know. I lost it totally. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Rojas.
Yes, ma'am.
You can go back with the
Thank you,
bailiff.
Your Honor.
That's what I get for not reading it. I'm reading it in my head. I don't even know where my copy of it is anymore. I've read it, I've said it so many times. But I can't stop in the middle and then restart. That's not good. Lamone Yeoman, Mr. Rojas. Give me just a second. I'm going to print these out. They're both MTRPs, and it's just easier to find me. 19. Good morning. Are you Lamone Yeoman Jr.?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
He will, Your Honor.
You should have another one coming also.
Yes, ma'am.
Okay. Mr. Yeoman, in cause number 19-32846, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 12th of 2019 for the offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 23, DCCR 1556, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for the state jail felony offense of burglary of a building. And that was a 2-year term in state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and specifically avoid association with any person previously convicted of a crime, or be present at a location where a criminal act is committed, in that you were supplying other residents of the Cheyenne Center with K2 synthetic marijuana. And is that true or not true?
First one.
It's true.
Okay. Count 2 in each case alleges that you failed to report to the probation office as directed April 2nd and April 3rd of 2025. And is that true or not true?
True.
Count 3 in both cases allege that you possessed a drug, K2, on or about March 30th of 2025 in violation of your order. Is that true or not true?
Not true.
Not true? Okay. Count 4 alleges that you failed to successfully complete the safety program as directed. Is that true or not true?
True.
Count 5 in each case alleges that you committed the new offense of possession of a controlled substance, penalty group 1, August 8th of 2025, and is that true or not true?
True.
Count 6 in each case alleges that you committed the offense of possession of a firearm by a felon, August 8th of 2025, and is that true or not true?
Not true.
Count 7 in each case alleges that you failed to report to the probation department April 11th, April 21st, April 30th, and May 9th, June 6th, and July 7th of 2025. And is that true or not true?
Not true.
All right. Did you enter your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of your cases, I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand I think y'all did the paperwork backwards.
We did originally, then we corrected it. At least I thought we did.
So,
It is a cap of 8 on 19-32846, and a cap of 2-year state jail on 23 DCCR 1556.
well, it's set, hold on. Anna, can you send me back 23-1556? I just sent it.
That may be the third degree paperwork. I think he may be right.
Whoa, courtroom timeout. Wrong paperwork. Wrong case details. And everyone hits pause. It may seem technical, but in criminal court, paperwork errors can change everything. Accuracy isn't optional. It's critical.
Yeah. Okay. I think, so 23-1556 is the burglary of a building, but y'all did TDC paperwork. And the other one, yeah. So those have to be right. So
We can read them.
I'm going to delete both of those.
That's fine, Judge.
I'll just hold this. We'll continue the hearing. I'm not going to go back over everything. We'll just go over the paperwork as soon as it comes through. And did y'all do it twice? You
We
said?
did, there was,
I got the numbers wrong. We did them.
Okay,
I'm happy to redo them both.
sorry.
That's my fault.
All right, I'm going to delete both of those. All right, y'all just go have a seat in the jury box and we'll get that done. Let me delete that. I started, I was looking and I was like, wait a minute, that's because I thought it was a cap of 2 on the TDC case. I'm like, what? Okay,
Yeah, I forgot there were different levels. Luke caught the mistake. I thought there were different levels. That's all.
okay.
Do you want to plead Hendricks now, or do you want to do them when we do the other guy?
Go ahead and get that one done, and that way I don't keep this over here and get confused for too long, and I'll take care of a couple other things. Let's see. Mr. Kimler, you have Sheena Harmon.
yes, Judge, if I can, there's no family members here on the sentencing.
Yeah,
With
which
Marvin,
one?
It's Christopher James.
Okay, I'll take care of it next.
Thank you.
Would y'all put that Christopher James sentencing up here for me to do next, please? Thank you. Ms. Malfino on Colton Armstrong with Mr. Kimler. Is it yours?
This is Harmon. This is
What did
Harmon.
I-
This is Harmon.
Oh, that's why never mind. Just testing everyone. Okay. Gosh, I feel like Monday. All right, are you Sheena Harmon?
Yes, ma'am.
Not Colton Armstrong? Are you sure?
Yes, ma'am.
Okay. And will your client waive the formal reading of the indictment?
So wait.
Okay, we're going on all of the counts.
Whatever
Or
makes
at
it
least-
third.
Okay,
Whatever
got it.
gets us with the judges.
Okay, I got it.
I think we're gonna need all of them to get us to it.
Okay. Ms. Harmon, in clause number 25, DCCR 0649, you're charged with the state jail felony offense of tampering with electronic monitoring device, and that's from April 30th of 2025. The indictment alleges that you were previously convicted of the state jail felony offense of theft, June 28th of 2010, and then you were also convicted of the state jail felony offense of theft on June 24th of 2013, and on that same date, the state jail felony offense of possession of a controlled substance. And how do you plead to that charge? And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Harmon is not competent?
There is none.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find those prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of tampering with electronic monitoring device, sentence you in accordance with your agreement to a term of 6 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I will also hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right, good luck to you, ma'am. You can go back with the bailiff. I thought I printed, my printing thing is being, okay. Let's see, let me take care of Mr. Armstrong real quick, and then I'll take care of that sentencing. Colton Armstrong, Mr. Kimler.
Just pleading this is a third degree.
Thank you.
He's gonna have to plead true to the answer. I guess there's some person. I mean, just here.
Good morning, are you Colton Armstrong?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
So, one, two.
Mr. Armstrong, in cause number 25, DCCR 0002, you're charged with the state jail felony offense of theft of property from February 21st of 2024. Your indictment alleges that you were previously convicted of the state jail felony offense of driving while intoxicated with a child passenger, October 31st of 2022, 2 cases on that same date of that same offense, making this a third-degree felony punishment range. And how do you plead to that charge?
Guilty.
And are those 2 prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. There would not be a fine, but you would be ordered to pay restitution in the amount of $20,000. Is that your understanding?
Yes, ma'am.
Do you also understand, excuse me, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection,
It's admitted. Is there any evidence that Mr. Armstrong is not competent?
there's none, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. Ms. Malfino, what's the state's position with regard to...
Now the stakes just got real. Probation on the table, restitution hanging over his head, pending cases in another county, and family pressure building fast. If you were the judge, would you give him another chance?
bond?
Judge, may I just put one thing on the record first before that?
We're gonna come back for some.
Obviously, I was a little bit hesitant to make this offer based on those priors, and I just want Mr. Armstrong to be aware, I have relayed this through his attorney, that if he does not pay this restitution back, I won't be asking for the minimum that I offered him today, 15 months. I'm going to ask for 10 years based on the opportunity that he's been given. I don't know that he doesn't have a hold in Hardin County. And I'm not saying that disrespectfully. I just want him to be aware of what he's just gotten himself into if
Sure.
the court follows the PSI. So I don't know if he has any hold.
I believe he does.
I'm a little hesitant to allow him on bond before you review the PSI, but I'll defer to what you think.
It sounds like based on that, and there is a hold from another
I
county.
can't say that they put a hold on him. I don't know. I know he has pending cases in Hardin County. I can't speak to whether there's a detainer on him from Hardin
And I've
County.
tried to reach out to Mr. Hopper over there and not that much.
Bruce.
He does have a pregnant wife, Your Honor, that's due fairly soon.
31 weeks.
31 weeks. Almost said 31 months.
Oh my gosh, wouldn't that
Feels
be?
like it was.
It does.
I wouldn't know. I think he has an unauthorized use of another vehicle and a theft of the same vehicle in Hardin County.
He does have 2 Hardin County holds.
So those would have to be cleared as well.
Yeah, and by the time, I'm afraid if I set a bond and then they get them over here, then we're not going to get the PSI. It's just going to prolong everything. And I think I'd rather go ahead. I'm not going to adjust the bond at this time. Let's get it taken care of. And then as soon as sentencing gets here, if everything goes well, you'll be released, at least from our custody. And then you can go take care of your Hardin County cases. All right, you can go back with the bailiff.
Thank you.
Thank you.
Thank you. Who's crying? I haven't even done anything to, I haven't even been that mean yet today. That I'm about to. I would probably be too. Mr. Lewis, Christopher James, Mr. Mr. Nichols.
Christopher James.
Good morning. Are you Christopher James?
Yes, ma'am.
And Mr. James was previously in court, entered a plea of guilty to the first-degree felony offense of intoxication manslaughter with a vehicle. I've received the pre-sentence report and also a supplemental memorandum from probation that includes several letters from the victim's family members. Has everyone had an opportunity to review all of that?
Yes, we have, Your Honor.
Are there any additions or corrections to that pre-sentence report?
No, Your Honor, I just want to make the court aware, Mrs. Addison, the deceased's wife, would have been here today to do victim impact. She had to go to the hospital yesterday. She's able to tune in, I believe, and watch us. The rest of Mr. Addison's family is here, and his mother is going to want to do victim impact at the end of sentencing.
Okay, thank you, Mr. Nichols. Any witnesses with regard to sentencing?
No additional witnesses, Your Honor.
All right, Mr. Lewis, you may make argument.
Okay. Judge, of course, this was a very tragic situation that has affected a lot of people. Of course, the decedent, Mr. Addison, his family, as well as Mr. James and his family. It was a situation where, this was a combination of a long substance abuse history of Mr. James. The assessment that's provided in the PSI here says that there was about a 20-year relationship between Mr. James different substances over a period of time. We have, the one thing I can say is that once Mr. James went through this situation with this accident, he has been doing everything he can to try to better himself. He has got his high school diploma. He's was baptized and has definitely changed his ways and going to his faith and continuing in that regard. He's also got some different certifications that he was able to receive dealing with OSHA, I think it was Men's University, things of that nature to try to better himself, Judge. Now, it's no secret he does have a long criminal history. That even included dealing with PCP, which is the same substance that was involved in this accident. And as well as, other serious offenses. I do want to address something as far as, I know there's some situations here dealing with the jail instances, and I know how the court proceeds or looks at the situation here dealing with those. Mr. James, if you look at these situations, majority of them did come from situations involving him and other inmates, as far as any type of fight or anything like that, which unfortunately some things he can't avoid. But as far as anything dealing with being disrespectful or anything towards jail employees or things of that nature, there's one situation I think that they were talking about that it wasn't an actual write-up, but it was notated. He has been a trustee over there for a period of time at the jail as well. Now, I do want to point out that, of course, some of those situations that Mr. James was able to do to better himself, of course, could definitely increase his earning potential as far as what he has as far as his job situation. He does have significant family support. His brother is here today in the courtroom, who in any way is there to try to help him, including helping secure employment. My understanding is the plan, once he is able to be released, is for him to be moved to Houston, Harris County area, to be close to his brother, to help him with everything over there. Now, PSI did have a recommendation for his different vehicles that support that's available to him through the probation department. What I will say is that everything that has been recommended, he definitely needs and will be better for him. We are not, and ourselves are not asking for a specific number or anything like that. We just want him to be able to, of course, make amends for this situation as much as possible, which could include some of the restitution there. I think the amount is over $100,000 for his restitution there to the family. Now, like I said, he has made a plan to try to better himself. He has a family that supports him. He is doing everything he can. He understands that this was a tragic accident, but one he was definitely responsible for. And what we're asking for is as much leniency as possible from the court, for him to be able to move forward with the situation, be able to make amends as much as possible. And I think he did provide a letter to the court as well to kind of speak to that as far as an apology letter that was to the family, his family, the family of the victim, as well as to the court, Judge.
And I've received that.
And so that's what we're asking for today, Judge, is for everything to be considered. We understand this is, you can't bring that person back. He can't just go back to make amends with Mr. Addison. But he wants to try to make as much of amends he can to society and do better going forward, Judge.
Thank you, Mr. Lewis. Mr. Nichols?
Your Honor, I think any consideration to Mr. James's due was given when he got a 50-year cap. I have no hesitation asking the court to exercise the full 50 years. This case is one of the worst intoxication manslaughters. It's on video where he plows into Mr. Addison, who's at a stoplight on a motorcycle, and while trying to get away, runs over him and the motorcycle again. It's horrific, Your Honor. What is also just inconceivable to me is that a man who's on parole for several possessions of phencyclidine, PCP, finds himself behind the wheel on PCP again. And this time it ends in the death of somebody. His criminal history is extensive. It starts with minor drug offenses, then a conviction for aggravated robbery, and then I believe it's 5 drug convictions all at the same time in 2020, for which he was quickly paroled out and on parole when this happened. The fact that he gets to make plans in his mind for a day he's set free, I find rather offensive, and I think the Addison family finds offensive. They lost a son, a brother, a husband. There's nothing we can do in this courtroom makes that better. And sometimes the justice system is a poor substitute for what people lost. I think the best we can do at this point is this man spend 50 years in prison where he cannot hurt anybody else due to his own selfish decisions and continued use of substances. It's in the pre-sentence report. He minimizes his own addiction, his own dependency. He even claimed he did not know how he could have gotten PCP in his system the day this happened, that maybe he touched a bottle and it transferred through his skin, and I find that reprehensible, Your Honor. And that's why I'm asking the court for that full 50 years.
All right, thank you. So, Mr. James, a couple of things that Mr. Nichols didn't say that I think are also extremely important is this isn't your first driving while intoxicated. This is your third. And so you didn't learn in 2006. You didn't learn in 2017. 2017, you got your second DWI. You were given probation. It was revoked. I appreciate that you entered a plea of guilty, because for myself and for the family, I'm glad we didn't have to see what it looks like this would look like on a video, because it is just horrible. And the fact that you are truly saying that you think you touched something and got PCP when you have had PCP cases over and over and over again, and you're on parole for possession of a controlled substance and you kill someone. It's a nightmare. Sure, go ahead.
Can I say something? You know, that night that accident happened, I've been clean the entire time I was on parole. Okay, I stopped off at a friend's house and gave him some advice about what he was doing. And during that time, I did contact a bottle of his. You know, I was not high at that time at all.
It was in your system.
Yes, ma'am. If you know how I fight you.
At this time, based on your history, based on the nature of this offense, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter. I'm going to sentence you to a term of 50 years in the institutional division of the Texas Department of...
And this is the emotional turning point of the entire hearing. A deadly crash, addiction claims, a grieving family, and prosecutors pushing for the maximum sentence. When tragedy, accountability, and past choices collide, what does justice actually look like?
Correction. There will be a deadly weapon finding based on the indictment alleges a deadly weapon. You will receive credit on this sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement and I followed it, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. There's really so many other things I could say about how horrible this is, and rarely am I out of words, but I really don't have the words to say what a tragic circumstances based on your behavior this led to. Y'all can have a seat at council table for the victim impact statement, and we'll go off the record. Do you want me to leave it on for the other family member to
I
hear?
think that would
If
be
the